Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitted across the internet. This is episode 297 of Registry Matters. Good evening, Larry. Good evening, Chance. How are you?
I'm doing fine, but where's Chance?
Chance, crickets. That's all I hear is crickets. He apparently has COVID after his long travel, so we all wish him very well. He was possibly going to join us tonight. He had it yesterday, and I talked to him, and he has taken a turn for the worse, and hopefully he recovers, and we will see him next week.
That would be my hope, because I need some time off. I'm older than he is. He's only 65, and I'm 182.
Right, of course. Remember to show your support by hitting the like and subscribe button or a 5-star rating in your favorite podcast app. It really makes a difference for us. We truly appreciate your love, and in return, we're here to keep delivering content you'll enjoy. If you're feeling generous, Patreon support would also be incredibly valued. Thank you for being a part of our community, but you can also download the show as a podcast and listen in your favorite podcast app. So, with that said, what are we doing this episode?
Well, we have some good stuff and some annoying stuff. We have a decision from the Illinois Supreme Court that deals with PFR restrictions. We have a case from the U.S. Supreme Court that interprets provisions in the First Step Act. And we have some listener comments and questions. And we have a plethora of articles, but we're not going to get to them, I can tell you that. But we might get to at least one of those articles.
Oh, I'm reading the reminder I wrote to myself, and I was like, what did I write a reminder? Oh, so tell me about you, just quickly, tell me about you bunny hopping curbs with your car. Do you know what bunny hopping is?
No, I don't, but I can send you a picture that you can distribute to the universe of how fun, how funny it is.
But bunny hopping, when you were a child and you would be riding your bicycle and you would actually lift the whole bike, you would jump and the whole bike would come off the ground just by you jumping. That's bunny hopping.
Okay, now I know. I don't think I did that.
Oh, all right then. Well, so tell me just a quick story about your bouncing your car. Maybe I'll make it the title picture of the show.
Well, I have OCD. Have you noticed that?
I've heard about this.
Well, I like a clean neighborhood and I like things to be tidy. So if I see something that I can take off the street in the way of trash, it's not too much work, I'll do it. So I was on my way home and I saw an unbroken bag of trash and I was going to pull over and toss it in the trunk and get rid of it. But while I was staring at the bag of trash, I continued my wide turn to the left and I hopped a curb.
You didn't just hop the curb, Larry. I saw your picture. You demolished your rim.
I did indeed. And I think you're going to be able to agree that this is funny. A young man in his 20s followed me. He was visiting his sister or a neighbor or something, but he was in the neighborhood and he followed me. And I was only a block from home, and based on how hard I hit, I knew that the rim was destroyed, the tire was destroyed. In my mind, all I could do would be to continue on home rather than calling for a tow truck and dealing with all that. And plus, I didn't have a spare tire because it got stolen when the car was broken into.
We never heard about that story. I don't think we talked about that one.
So this young man follows me, and of course he followed me simply because he was trying to figure out what kind of psychotic nut would drive on the rim. And he had to see that. He was probably, in hindsight, making a YouTube video of me, but I didn't catch on to it at the time. And so he politely, when I get out of the car, he said, sir, you know your tire is out. I said, yes, I know that. I said, I was so close to the house, I just decided that I could do no additional damage and I wanted to be in the driveway here. And he says, well, I'll change the tire for you. And I'm thinking, well, that's very gracious. I said, well, that's a great offer. I said, but I don't believe there's a tire in here because the car was vandalized. And I think the tire is one of the things that disappeared. And so we opened the trunk and of course there was no tire. And he looked at me like I had beamed in from someplace beyond Mars. Here I am running on a rim and I don't know that I don't have a spare tire, and I don't even know whether I have one or not. And he had to have thought that was funny. So I have a good idea. If you Google nut driving on rim, you'll probably find him talking to me because he was so polite about it, and I'm sure he was making a YouTube video.
All right. Well, I will share that picture in Discord later. And the way you get to Discord is go to the show notes and you'll find a link in there to get to our Discord server. All right. Well, then move along. So, hi, guys. Love the podcast. I'm from Louisiana. That would be Louisiana. And it doesn't seem like there's a lot going on in this state with people involved in fighting the registry. I don't even think there's anyone working with NARSAL. However, I have a question. There is a dollar amount. Is there a dollar amount of what it costs on a national level to enforce RP? What is RP?
I would assume it's registered persons, enforcing on registered persons.
Okay. Well, then I guess that would clear up with the next sentence. And I'm sure that the registry must be approaching 1 million people. I had read an article while I was in federal prison that it costs the state of California $55 million a year to watch over the more than 100,000, and I'm just going to change it to PFRs. I would think nationwide it has to be close to $1 billion. Hope you guys have some info on this and include the answer on one of your podcasts. Keep up the good work for all of us. Thanks. And that's from Mike.
So, well, my observations are very interesting. It probably does cost a huge amount of money, but the costs are so splintered because of the structure of the registration. Most states decentralize it off to local law enforcement. It'll be the responsibility of an elected county sheriff, for example, or police departments. And those are political arenas that you have to play within. But if you're elected sheriff, you probably need to keep a good eye on the PFRs. So therefore, elected sheriffs use those opportunities to pontificate about what they're doing to keep the community safe and to garner votes. And they do more than what's actually required by law. Like all these house checks, most of the time, those are not required by the statute. In a few instances, they are. But all these home visits, they're not required. And so the cost is being driven up higher by political maneuvers for the people who are enforcing the registry. And then you have some offsetting federal money coming from the Department of Justice through the Sex Offender Registration, Monitoring and Apprehension, the SMART Office. You have grant money available for local law enforcement to do those compliance checks. So you could probably easily obtain that money through a Freedom of Information request from the Department of Justice, how much money they're giving local law enforcement and grants. Someone could submit such a request. But in terms of being able to get an accurate calculation for nationwide, it'd be almost impossible because the costs are hidden. You could probably extrapolate if you contacted the West Virginia State Police, where they manage the entire registry. There's a few states like Pennsylvania State Police. If you were to go to those states and see if there's a similarity in cost, you could probably extrapolate and get some kind of idea. But it would be a very difficult project for anybody to do. I don't have the inclination to do it, but it would be interesting to know that.
You don't think what do you think the number is? So he says approaching 1 million. There are people that are double counted, and even like Florida, with every person under the sun that has ever visited the state is on their registry. Do you think it's 1 million? Do you think it's 750?
It's hard to say. I think it's certainly less than the 1 million because there's obviously some double counting. But if it's 750,000, and if it's costing hundreds of dollars per registrant for the annual home visits and tracking, it could be a substantial amount of money. But I'll tell you this, money doesn't necessarily control things. There's a state kind of in the center of the United States. Have you ever heard of it? It's called Nebraska.
I have heard of Nebraska before.
Well, they were able, maybe about 10 years ago, to repeal the death penalty in their unicameral legislature, and the governor vetoed it. They were able to override the governor's veto. And everybody knows it costs more to execute a person than it does to keep them in prison for life because of the endless appeals.
Yeah.
And it's very costly to execute people. And the citizens through some process that exists in Nebraska, despite all the data being available to them, they reinstated the death penalty. So cost doesn't necessarily, when there's an agenda to be had to accomplish an agenda, cost do not necessarily stand in the way. I don't think that the average American would give 2 cents worth about what's been spent on the registry. I think they'd think it's money well spent.
I bet you the population as a whole thinks that when someone is convicted of murder and they're sentenced to the death penalty, sometime next week they are removed from the planet.
It'd be hard to think that people really believe that, because you hear about what each time there's an execution, you always hear that the crime was committed 10, 15, 20, 30 years ago. I don't know how you could reasonably assume that it's happening quickly when it's decades, sometimes as much as 30 or plus years before they're executed.
One other thing that I wanted to bring up in this is that it, like you said, it would be really hard to get the data. But there's not like an itemized list of Officer Smith going and visiting XYZ PFR's house, spent 15 minutes doing this. He gets paid $50 an hour, and therefore that's, 1/4 of an hour for that to go through. There isn't an itemized bill of what an officer does on their shift to account for how much they spend on PFR compliance checks, whatever you want to call them.
You're correct. But in the larger departments, they tend to have sex offender monitoring units particularized to that task. If you're in a small department that has a total of 30 officers, everybody does a little bit of everything. But if you're in a more urbanized area where there are hundreds and hundreds of officers, like for example, our county, I think last count, they had either 7 or 9 trackers, as they refer to them, that are sheriff's deputies that are assigned to the sex offender registration and monitoring unit. And then they have a number of civilian support personnel. So that would be a lot easier to identify those. If you have a unit that's particularized for that, you would look at the cost of sustaining that particular unit. But it would be a very difficult task to achieve.
Yeah, without a doubt. And you have a certain interesting mission of moving it. Before we go there, you have a term that you use this when for a sheriff to go and monitor the compliance of PFRs. The mandate, what do you call that?
I'm not sure what the question is.
You have a term for it, that it's an unfunded mandate at the local level.
Yes, it is an unfunded mandate.
Describe that.
Well, it's easy to pass a law in the state capitol and say that the sheriff's department shall be responsible for monitoring and tracking the PFRs, and then not provide any funding from the state. So all of a sudden, the counties are tasked with doing something, but there was no funding attached to that mandate. And it's a mandate that they can't speak out against. Because can you imagine in Georgia, 159 county sheriffs, if they started griping about being tasked with the responsibility of tracking PFRs, what do you think the reaction from that county's voters would be if they made it clear they didn't want to track PFRs? What do you think the reaction would be from the average voter?
I believe they would unhire him.
That's the reason why the sheriffs have to maintain their silence, and they have to, unless they have enormous public support, they have to keep their mouth shut whether they agree with it or not, because to speak otherwise could jeopardize their jobs. And I know it shocks people, but they have families, children to send to college, mortgages to pay themselves, just like everyone else. And it's kind of their job, and they don't want to lose it over something like that.
Here we have a comment from Michael in Texas, and I'm writing to you 2 pieces of good news I received last week. One good, actually great, and one bad. Good news first. 1, March 8th, 2024, I was granted parole. I'll be released as a somewhat less unfree with all the parole and dreaded Texas registry restrictions, which lists our shoe size for an unfathomable reason. I don't think he's joking there. Do they actually list the shoe size in Texas?
I'm not surprised, but if that's true, would you concede that that's funny?
Oh my God. I mean, he's saying that, and it doesn't sound like he's saying it in a joking manner. Oh my God. Okay. Random home inspections. Everybody deals with that. P-test, same thing. Weekly therapy sessions, annual polygraph interrogations, visits to 2 local popo every 90 days. I can't wait. But now the bad news. I was planning to parole to a faith-based halfway house called Now Name Ministries. Okay. But then on February 29th, I was informed with the city of Fort Worth pulled their license. Oh my God. And ordered them to close, likely in retaliation for allowing PFRs to parole there. I had written to 40 other halfway houses and received nothing but no SOs, or SOs yes, SOs with minor victims no. My charge is distribution of CP. So to me, it seems like whatever someone sticks their neck out for us, they get slapped down. In that vein, I'm contemplating a post-discharge relation to Larry's neighborhood to the north, the communist state of Colorado. That's how you get off the registry in Texas. By U-Haul or by horse? That's a very odd spelling of horse. And it's sad. My ancestors came here in the 1850 during Larry's wild youth. Oh my God. Okay. My Alexa wanted to chime in. And I love Texas, but Texas doesn't love me much. I'm under no illusion that Colorado is some Shangri-La utopia for PFRs, but what I've heard from Colorado-based SOs on Reddit page, How I Discovered This Podcast, it seems very good compared to Texas. No one-year driver's license, no Halloween lockdown nonsense, and a chance for removal. Sign me up. I think if everybody could move about 3 states north, they'd probably be better off.
Yes, I think he might have meant Hearst there, but I'm not sure.
It could be that. Yeah.
I had this.
Or he lost his voice.
I had this typed up because it was so long, and I cut out the salient points from it. But this is a funny letter, and the fact that he is incarcerated and he receives our transcripts, and he wrote. Clearly, he's reading because he came up with the communist state of Colorado, because we talked about that
Yes.
recently, of the person who wanted to go back to Texas, and this is just kind of ironic. Now, the freedom-loving state of Texas is not where you can get off the registry. You have to leave the state or die to get off the registry. I guess apparently they take you off of the list when you pass away in Texas, maybe. But the state that proclaims its fondness for freedom and individual liberty doesn't do nearly as much for you as the communist state. Now, can you admit that's funny?
Yes. Not funny. It's not funny.
So,
What do you recommend for this individual on him moving by hearse to Colorado?
well, he's going to run into some problems, but probably not as much as a person with a state conviction. If I remember right, he's in federal custody, but I'm not certain. But he should be able to transfer a little bit easier with his federal supervision. But if he's in state custody, he's got to get Colorado to agree to accept him for the duration of his supervision, and that's a process in and of itself.
Well, all right then. Hey, if you're in Fort Worth, enjoy the eclipse. I'm envious.
All right.
You familiar with the eclipse?
I've heard about it.
Okay, it's coming. And I won't be here. Just letting you know, 2 weeks, not going to be here. Going on a long road trip to go see an eclipse. Next up, this one came in like an hour ago. It says, question for number 1 for Andy. What, if anything, is your experience in this regard? Have you noticed whether or not your name has dropped off these sites? And there wasn't anything before it, so I will fill in that. Go Google your name. You find all the different websites that have your name posted. How long did it take for them to update you off of their databases? And Larry, I don't want to hear about it's just a website. Now, just before we started recording, I Googled my name. Now, I have Googled my name periodically, maybe like once a year or so, just to see where I fall. And I have never shown up. If you Googled my full name along with the city I was living in, then I would show up. But I've never shown up. And I know that I'm very fortunate, and I don't have a common name, but my stuff really didn't ever hit the paper or anything like that. So another bullet that I have dodged is that I did not end up some high profile thing where I was smattered all over either Facebook pages or news sites or whatever for me to get picked up in the whole Google trove of data. But so how long does it take? You'd have to ask other people about it. Some other people I'm sure have different information. But I know what Larry's going to come up and say next is that if these other companies go and get your data either by scraping the registry website information, or they have somebody that goes down to the county courthouse and picks it up from the actual document. They're reporting true information. You were convicted of whatever. That's not a lie. So they're in business to sell that or promote that information along with ads sitting next to it. So, like, it's a capitalist country and that's what you get for it?
Gee,
Your turn.
why did you even have me come in tonight?
Oh, okay. Well, so I'll move on. I'll answer your question number 2 for Larry. Now, I'm going to answer this one. Just kidding. Do you have anything to add for question number 1?
No, I think you covered that pretty well.
All right. Well, then part 2 for Larry. If these websites continue to post inaccurate and harmful information about me after a reasonable period of time, do I have any recourse? It seems to me I remember reading at some time in the past that these outfits have been successfully sued. Give us the story, Larry.
Well, I don't know that I recollect any successful lawsuit. There's a advocacy organization based in California that did sue one of these outfits called Defendex. I don't remember that case gaining any traction. I think there was a battle over jurisdiction where the case should be grounded. I think it got transferred from California to Arizona, and then I don't remember the disposition, but I don't think it was a very favorable outcome. But I take issue with posting inaccurate information. I would need to know what is inaccurate about it. If it says that you've been convicted of a sexual offense, that would be historically correct. If it says you're currently registered, then you're bordering on something that might not be accurate. But if I were them, now I'm only playing devil's advocate here because this is what I do and get paid to do. If I were defending them, I would say, well, no, it's not inaccurate at all. In fact, we've got in number 6 font on our website, it says that the person's duty to register has been terminated. But that doesn't change anything other than the fact that your address is no longer up to date. So if you had a cause of action, it would be, the inaccuracy would be on the address if they continue to maintain that address where you were last registered before your termination, because he's in the pure Wind River state and he doesn't have to register there any longer. And if that last address, say for example, is no longer his address, that person I think would have a stronger cause of action because they would say that I've had Molotov cocktails coming through my house on a regular basis because of this. But he would potentially have some traction on a lawsuit in that regard because that would not be fully accurate, but merely the prior existence of his registration. I don't think that's going to gain a lot of traction. I'd be interested to hear if he's shopping around for attorneys, what they're telling him, because I'm not aware of any successful litigation in this area.
Because I go through this kind of thing at work, no one reports from the website that you get removed from the registry that you are no longer registering. They don't send out some kind of notification that so-and-so is no longer required to register. Your information just becomes stale. And they would have, perhaps they have a field that says last updated, the last time they saw it. But otherwise, they would just, do you time out records that you don't see after a period of time? Do you then put the thing on there that you said, like, I mean, this person was once registered and hasn't been updated in a while. So now you say we don't have data and you put it in such a small font that no one can read it without a magnifying glass?
Well, that's what I would do if I were them. That's precisely what I would do. I would put a disclaimer on our website to begin with, on Home Facts or whatever he's talking about, that these records are not guaranteed to be currently up to date, and that some address information might not be current. And then I'd put it even smaller font. I would say, any registrant who would like to update their information, here's the way you contact us. Send us an email.
Sure.
And so if you've been removed from the registry or timed out, you could provide that information and then we would update your file. But we've done everything we could to try to make it as accurate as possible. We've offered you an opportunity to update your record and to show us that you're no longer required to register. And we'll reflect that in our public disclosure, that you're no longer required to register. We'll reflect it in a way that not a soul can see it, but we'll reflect that. And what else is there left for us to do? Do you want to use the power of the government to prohibit an endeavor of capitalism from operating? And these people do this to make money. You don't want to use the power of government to interfere with private enterprise, do you?
Never, never, never. I wouldn't ever want our government to sign a law that says you can't use a certain application in this country either. Even though that application is completely toxic and terrible for your mental health, I still don't want them to do it.
Well, that's my point. If you're a capitalist, you don't believe in using the power of government, particularly in a free society where there's basically a constitutional right to provide information, and this information is largely accurate. But there might be something he can develop in terms of if he really struggles hard and tries to narrow the challenge. Everybody has trouble with narrowing their challenge. We're going to find that out in the next case here when we're talking about from the Illinois Supreme Court. They want to throw everything into the mix and hope something sticks.
Two comments. One, Amy says Axel had a conversation with HomeFacts about leaving people on their site after they've been taken off the registry. Janice Bellucci says she may be able to help people come off of their site. And then the second comment is about how about signing up with a site like Reputation Defender? They advertise about scrubbing the internet to help your reputation. I believe that would be your best bet as far as you're not going to come off, but who looks at page 12 to find information about anything? If you're not at least above the fold, if you're not on page 1, no one gives a crap. And so if somebody's looking for you hard enough, they're going to find you. But so sign up for a service that will help push your stuff down below, and then onto page 2 and on beyond. And that way you don't show up when someone types in your name and you show up on page 1 at the top link. Bling, bling, bling. This person is a PFR.
Okay.
Well, then I guess we'll do this case that is from Illinois Supreme Court dealing with residency restrictions. This is one of my favorite subjects. The case is Martin Kopf versus Brendan Kelly. Now, Larry, it is Saturday, and even though I'm in college now, I have a lot of reading to do. I read this multiple times, so you'd better be prepared because I have questions.
It's like 37 pages. Why on earth would anybody in their right mind read this kind of gobbledygook?
So I can actually try and trip you up and see if I can make you stutter and and so and make you relent.
All right. I thought it was because to let us know that FYP has talent.
Oh, well, there would be that. So there is talent at FYP, and I will set it up. Plaintiff Martin Kopf filed a pro se complaint in the circuit court alleging that section 11-9.3 B10 of the criminal code, which prohibits PFRs who offended against a child from living within 500 feet of a daycare home, along with other prohibitions and requirements in Illinois, is unconstitutional. Oh boy, you love pro se litigants?
Oh, I do indeed. They generally screw things up for everyone else that tries to litigate after they've made their messes.
The circuit court dismissed most of Kopf's claim. However, it held that residency restrictions violates the substantive due process clause and the equal protection clause. Please explain substantive due process.
Well, I had this section set up for Chance to answer, so then I had to do a quick research to fill in the blanks. Both of those protect us from unfair treatment by the government, and they're guaranteed in the Constitution, I think, but I'm not sure about the procedural due process. But substantive due process relates to the content of the law, meaning is it constitutionally permissible to legislate and prohibit or require something. So substantive due process determines whether a law violates the Constitution itself. And procedural due process is pretty much like it sounds. It relates to how the laws are implemented and enforced. And procedural due process would be like if you have a notice that something bad is going to happen to you and you want to appeal, that assures that individuals receive fair notice and opportunity to be heard before being deprived of life, liberty, or property. So that's the nutshell difference.
And the state appealed, right?
They did. And Copf, that's the plaintiff, cross appealed to argue that the circuit court erred in dismissing his ex post facto claim, his procedural due process claim, and the remaining substantive due process claims.
And before we get too far into this, how did Mr. Copf do as a pro se litigant? So if you were to grade him what do you think? How well do you think he did?
He actually did amazing as a pro se litigant. I wonder if he's actually had any formal training. I've never spoken to him, but he did, from what I can see, a very good job. Some of the mistakes that were made are often made by people who've been to years of law school.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
I thought that they knew everything, Larry, because that's how they make it sound. And that's how the people that support the lawyers make it sound. That how dare you criticize anybody that's a lawyer, Larry?
I know I get in trouble for that. There's some detractors out there on Reddit that criticize me for criticizing lawyers.
That is what I've heard. On the order on page 2 reads as follows. For the following reasons, we hereby vacate and remand the portion of the circuit court's order finding the residency restriction unconstitutional as applied to plaintiff. Reverse the portion of the circuit court's order finding the residency restriction facially unconstitutional, and affirm the portion of the circuit court's order dismissing the plaintiff's remaining claims. Let's dig into this a bit. What is the significance of the remand on the issue 1?
On that one issue, it's huge because it gives Mr. Copf the opportunity to provide evidence to support his claim that the residence restrictions are unconstitutional as applied to him. He didn't get flushed completely, so he lived to fight another day.
And what's the difference between facially and as applied in this challenge?
Well, a facial challenge, one can only prevail when there's no set of circumstances that would permit something to be done. And a facial challenge is almost, or inevitably, the most difficult for a person to succeed on. But on the other hand, an as-applied challenge does not require the same level of proof. Something could be unconstitutional as applied in certain situations, but not be facially unconstitutional, meaning that there'd be no set of circumstances that you could do it.
And that would be for anybody under any circumstances to be facially unconstitutional.
Yes, and that's why the registry will never be declared facially unconstitutional, because it is possible to do a constitutional registry. So therefore, you can't meet that standard that there's no circumstances, set of facts or circumstances that would permit registration of individuals. But you can meet the standard of showing that there are certain people who you cannot constitutionally register under the more stringent registration schemes.
Shall we continue? I kind of sidetracked with a quick question.
All right, let's do it.
All right. Well, based on that answer, I feel that we need to dig into a bit into Mr. Copf's situation, since it might be unconstitutional as applied to him. In 2003, Copf pleaded guilty to aggravated criminal sexual abuse involving a 15-year-old victim and was sentenced to 3 years probation, which he completed. According to Copf's complaint, on August 24th of 2018, he and his family moved into a house on Cathy Drive in Hampshire, which he had built the house to accommodate his special needs. He had relied on locational approval from local authorities, and he registered the address as required. Later in 2018, the Hampshire Police Department informed Copf that day that a daycare home was operating within 500 feet of his residence, and pursuant to the residency restrictions, he was required to move from his residence within 22 days. Copf alleged that he and his wife moved from Cathy Drive home, purchased a travel trailer, and moved into a local recreational vehicle resort in Marengo, Illinois. This is ridiculous. This sounds like the dude that moved to East Georgia had a similar situation. So, can you admit that this is ridiculous?
Oh, I can admit that. It's totally absurd. But it gets even more absurd.
Absurder?
Copf alleged after about a year, the resort owner notified him that he could no longer live there based on his status as a PFR. He moved to a motel until it was no longer cost effective to stay there. Copf alleged that after more than 100 rejections to his request to lease apartments, he slept in the back seat of his pickup truck and at various areas within the Hampshire area. In November 2019, Copf filed a pro se complaint in the circuit court, and on January 29, 2020, the circuit court entered a temporary restraining order enjoining defendants from enforcing the residence restriction. That allowed him to reside at the Cathy Drive address. Now, just think about this. This man got a probated sentence. He completed it how many years ago without any problems?
What was it, 2003 that he got just a couple month probated sentence?
Well, longer than that, but he got a probated sentence that he completed successfully, and he can't live anywhere. Can you admit that that's absurd?
It's definitely absurd. So we're talking, if the sentence was in 2003, so at least now we're talking about 21 years, right?
Right.
All right. In his second amended pro se complaint for civil rights violations, declaratory judgment, Copf alleged violation of the ex post facto clauses of the United States Constitution and the Illinois Constitution. Number 2, violation of the procedural due process of the United States Constitution and the Illinois Constitution. Number 3, violation of the guarantee of substantive due process of the United States Constitution and the Illinois Constitution. Number 4, the proportionate penalties clause of the of the Illinois Constitution. Number 5, and then there's just one more, so bear with me. Number 5, a violation of the 8th Amendment prohibition on cruel and unusual punishment and negligence principles in that the Illinois State Police Director and the Hampshire Police Department were negligent in failing to timely inform him that the location of his residence did not comply with residence restrictions. Of those 6 counts, only 1 is still active. Is that right?
You are correct. I'm telling you, you don't need me here.
You're fired. All right, I'll just keep going.
All right. Copf also included allegations that the residence restrictions and various provisions of the Residence Restrictions Act were void for vagueness, and that the residence restriction was void for violation of equal protection. I think that was in there of both the Illinois and the U.S. Constitution. The second amended complaint challenged the residence restrictions, other presence restrictions applying to PFRs, including one which requires individuals convicted of sex offenses to annually renew their driver's licenses. Copf also alleged that the Residence Restrictions Act, the notification law, and the driver's license renewal provisions create multiple irrebuttable presumptions. And I cannot explain that sufficiently. I asked Mr. Copf through email if he would come and explain that position, and he wasn't available. But anyway, he says it unconstitutionally relies on an irrebuttable presumption that he's dangerous and likely to commit further sexual acts and therefore invalid. And I think an irrebuttable presumption means just what it says, that a law presumes something and it doesn't allow you the opportunity to rebut it. But I don't want to go on record because my detractors might get mad if I do that.
So I am the layperson, and I'm thinking that this sounds like sort of like what Pennsylvania has in their constitution, that you can't harm somebody's reputation just because you were convicted of this doesn't mean that that's what your reputation should be. That's how I'm reading this. An irrebuttable presumption is, well, you did this, therefore the presumption is that you are forever this way.
That is what it seems like, yes.
That doesn't sound... So you can never live past what you were. So you were once 1 year old, Larry, therefore forever we're going to consider you a 1 year old.
Correct.
All right. Well, what did Mr. Copf ask for in the way of relief?
He sought 1, a preliminary and permanent injunction preventing the defendants from arresting or prosecuting him for violating the residence restrictions. 2, a declaratory judgment that the residency restriction is unconstitutional is applied to him. 3, a preliminary and permanent injunction preventing the defendants from enforcing the other provisions at issue against him. And 4, a declaratory judgment that the provisions at issue are unconstitutional is applied to him. He asked for a whole bunch of things. I'm not even sure I got it all in here, but I tried.
And, you know, a DA will prosecute you with throwing the kitchen sink at you and everything, hoping that you'll just take a plea of 1. Shouldn't we go to court and do the same thing back at them, Larry, and throw everything at them, hoping that one thing sticks?
Well, it's logical, but it seldom works.
It works for DAs. Jesus! All right, well, the court dismissed with prejudice counts on 1, 2, 4, 5, and 6 of plaintiff's complaint, but declined to dismiss count 3, or the equal protection allegations in the complaint. In its order, the circuit court entered a permanent injunction in favor of Copf and against the defendants, enjoining defendants from refusing to register plaintiffs at his address, taking any action to force Copf to vacate the property, or prosecuting based on the residency restrictions. What will happen next?
Well, defendants ask the Supreme Court to vacate the circuit court's orders and remand for further proceedings because those orders failed to comply with Illinois Supreme Court's Rule 18, effective on September 1st of 26. And that rule states that a court shall not find unconstitutional a statute unless the court identifies what portion of the statute is being held unconstitutional and sets forth specific grounds for the finding of unconstitutionality, including whether the statute is being found unconstitutional on its face, as applied to the case, or both. The Supreme Court, the Illinois Supreme Court, that is, denied defendants' request to vacate the circuit court's orders, but granted their request to remand the matter for further proceedings for the limited purpose of making and recording findings in compliance with Supreme Court Rule number 18.
The order states, on remand, the circuit court held a status hearing wherein defendants proposed submitting stipulated facts, or, if the parties could not agree to the facts, proceeding to an evidentiary hearing. Plaintiff objected, arguing that the court's limited remand order did not allow for an evidentiary hearing. Now, I'm confused there. Why would Mr. Copf object to having an evidentiary hearing?
That is a question I've been struggling with myself. The defendants they even sought clarification as to whether the circuit court intended to hold the residence restrictions unconstitutional on its face or as applied to the plaintiff. The circuit court acknowledged that it had no facts that would have specifically related to the plaintiff, meaning that they didn't make any particularized facts about it being unconstitutional as applied to him, and what was happening on his block, and stated it had held that the challenge provision was facially unconstitutional. The circuit court stated that its holding was addressing facially the definition of home daycare and interplay with residency restrictions. The circuit court stated that the residency restriction was facially unconstitutional because it was not rationally related to its purpose. It sure sounds to me like though Mr. Copf made a strategic blunder. He could have had an evidentiary hearing, but declined. On page 7, it states, initially, we note that absent evidence in the record with regard to plaintiff's specific circumstances, the circuit court erred to the extent it found the residency restrictions was unconstitutional as applied to plaintiff. Why would you decline an opportunity to go in and give evidence? I'm just befuddled over this.
And I see that. And then the order states, although facially and as applied constitutional challenges are both intended to address constitutional infirmities, they are not interchangeable. Would you do me the kind and explain what the difference is between those two again?
Well, I did it earlier, but I'll actually, this time I cut and pasted from the opinion because they actually did a pretty good job. A party raising a facial challenge must establish that the statute is unconstitutional under any possible set of facts, while an as-applied challenge requires a showing that the statute is unconstitutional as it applies to specific facts and circumstances of the challenging party. End of quote. The court went on to say, by definition, an as-applied constitutional challenge is dependent on the particular circumstances and facts of the individual defendant or petitioner. Therefore, it's paramount that the record be sufficiently developed in terms of those facts and circumstances for process for appellate review. The court has explained, let me go back on that. This court has explained a court is not capable of making an as-applied determination of unconstitutionality when there has been no evidentiary hearing and no findings of fact. Without an evidentiary record, any finding that a statute is unconstitutional as applied is premature. And end of quote. Does this help you to understand the reason why I'm so adamant about evidentiary hearings and having a record?
Without a doubt, it does. I don't see how you would work it any other way, unless you're trying to circumvent the system that you don't want the evidence in there,
Okay,
and you're
but
trying to do a oop-de-doo on them.
you know how I go bananas over all these motions for summary judgment?
I do.
Okay, well, this is a living, real-time example of why I become unhinged. If you look at these, the consistent thing in these decisions is courts say repeatedly, there wasn't enough evidence. Okay, I don't even have a law degree. I don't understand why people that have gone to law school can't understand this if I can understand it and they can't.
A comment in chat real quick. It sounds like the Supreme Court was giving him a chance to present evidence, signaling they were open to a ruling in his favor. They could have just dismissed the count. He thought the ruling was against him, so he objected? Do you think that's what was going on?
I don't think so. I don't think he was able to understand the significance of an evidentiary record. When you win a secure a victory against a statute being unconstitutional, remember, this is manifestly strong medicine because you're slapping the face of the citizens and the entire process. You're saying you didn't have the right to do this, and you need overwhelming evidence to do that when you totally nullify the work of the people. And so therefore, every time you go into a constitutional challenge, your goal should be as much evidence you can get into the record that supports your claims. This is where too much is a good thing. The more evidence, the better. Stipulated facts are not going to usually carry the day because the state is not going to stipulate to facts that's going to help you and hurt them. They're just not going to do that.
I see that on page 8 they said, in this case, the circuit court did not hear evidence regarding plaintiff's specific circumstances before ruling that the residency restriction was unconstitutional as applied to plaintiff entering a permanent injunction in plaintiff's favor. Instead, the record contains only unverified allegations.
But now, can you please admit that that's funny? Because we got to have at least one admission.
I'm never going to admit what you say is funny. I thought you had promised to work on understanding the definition of funny, because yours is not the same as everyone else, and that's not funny. Defendants argued that plaintiff abandoned his as-applied constitutional challenges with regard to the circuit court's order finding the residency restriction unconstitutional pursuant to substantive due process and equal protection principles because he objected to an evidentiary hearing during the limited remand from this court. Did they accept that argument?
They didn't, and that is a gift that he was given. If I were on that Supreme Court, and if the record clearly showed that the party didn't want an evidentiary record, I would be inclined not to give him a second bite at the apple. I think they're giving him a second bite at the apple because he's pro se. But this is what we have a little clip that somewhere out there where when the judge says, "Why would we let you go back?" That was Kansas. "Why would we let you go back and do what you should have done to begin with? Why are we here?" I mean,
I do remember why are we here.
Yeah, they're giving him a little bit of slack here.
I noticed on page 24 that they stated this court has held that a PFR does not have a cognizable privacy interest in his registration information, and thus the provisions of the Registration Act and Notification Law allowing extensive transmission of this information, including a PFR's photograph and physical attributes via the internet, do not implicate the expanded privacy protections afforded by the Illinois Constitution. What about that?
Well, unless you believe in legislating from the bench, we need the people of Illinois to change the law and provide that protection. It's not there, folks.
Can you at least admit that the dissemination of PFR's information on the internet should require that the person be deemed dangerous?
I can agree with you in principle that I would like it to be that way. Unfortunately, the law doesn't provide for that. This Illinois Supreme Court ruling relied on the U.S. Supreme Court precedent and the Connecticut versus Doe versus Connecticut Department of Public Safety. And the Supreme Court held, because Connecticut's PFR registration system turned on an offender's conviction alone, a fact that the convicted offender has already had a procedural safeguard, an opportunity to contest. Connecticut was not required to hold a hearing regarding current dangers before requiring registration because the conviction was relevant. Only the conviction was relevant to the disclosure of information. The Supreme Court held that hearing on current dangerousness would be a bootless exercise because current dangerousness was of no consequence. Accordingly, the Supreme Court held that due process does not entitle registrants to a hearing to prove an element that has no relevance to the issue of registration. That's what the U.S. Supreme Court said, and they are the final decider.
As we are running very long on this, we need to get out of here. And I'll read the conclusion. In sum, we vacate the portion of the circuit court's order entering a permanent injunction on the basis that the residency restriction was unconstitutional as applied to plaintiff. We find that the circuit court prematurely held the residency restriction unconstitutional as applied to plaintiff, considering it had no evidence before it to do so. We therefore remand the cause to the circuit court to hear evidence on plaintiff's as applied constitutional allegations and to conduct further proceedings consistent with this opinion. This is on page 38. So what is next for Mr. Copf?
He gets the second bite of the apple. He better have evidence when the circuit court holds evidentiary hearing. The circuit court is going to be keenly aware, based on this 37, 38 pages, that they're going to get slapped down if they find this unconstitutional without evidence. Mr. Copf, come in with evidence if you want to win.
And so I'm kind of the same mind as PA Dad. So he lost, or it ain't over yet? Could you give us the one sentence answer?
He lost on every count except one. And
Lost on
that
every
one
count
lives,
except one.
that survived for him to prove that it's unconstitutional as applied to him. That's the only thing left standing.
And you have been in contact with him? You've had engagement back and forth?
Not since this came out. Previously, when he was seeking help on this, we had communicated through Illinois Voices, and we'd had communication, but he was never willing to come on the podcast and explain his case. And I said, well, if you can't explain it, I certainly can't. So I wanted him to come explain and articulate. I said, prepare the questions you'd like to be asked and be ready to defend your position. We will play devil's advocate, and I'll pretend like I'm the state, and we'll have fun with it. But he didn't think he could do that, or for whatever reason, he didn't do it.
I see. If it were you, would you be hesitant to do it?
Unless I thought the person was qualified, yes, I would be hesitant.
But I'm assuming that we all think that you're qualified.
Well, assuming that he thinks I'm qualified, I would take advantage of anytime you can do a mock trial with somebody who knows what they're doing on some level. You ought to take advantage of that if you're trying to win a pro se case.
Well, does your voicemail, your caller ID, does it say crackpot?
I don't know what it says.
Because I'm wondering, maybe when you called him, it said crackpot and he wasn't interested.
No, it didn't go that far. He just did not respond favorably that he wanted to have communication about the case on the podcast. He said that he wanted somebody else to do the work. He recommended that we get Mark Weinberg to, and I said, Mark, it's not Mark's case, it's your case.
Yeah, sure. Okay, well, you put an article in here. We have a couple minutes to kill, and this is from Roll Call. I don't know Roll Call, Larry. Do you know about Roll Call?
Is that the First Step Act?
Yeah, this is the First Step Act. I just don't know this website called Roll Call.
Yeah, I don't know it either. Okay.
All right, well, this is, like I said, from Roll Call. And it says, Supreme Court limits who qualifies for safety valve sentencing law. Justice Elena Kagan authored a 6-3 opinion. Now, look, Larry, she's in a very, 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 very strong minority. So how was she in a 6-3 opinion?
I don't know. We'll figure it out when we get there.
All right, and so the case is Pulsifer versus the United States. The case is about the First Step Act. It was planned for Chance to lead the discussion, but he decided to bail out on us. But since he's not here, can you do some damage uncovering it?
I'll try, but we're going to be very brief compared to what we would have been.
So Justice Gorsuch was in on signed with the liberal pointy heads.
Yes,
for this?
There's 66 pages of decision. There was a strong dissent of the 3 dissenting judges. And so we have 5 conservatives joining with Elena Kagan. So you got one pointy head, and then you've got the conservatives that carried the day. and you have Justice Gorsuch siding with the dissenters. He's deciding with he's joined a dissenting opinion of the two liberal pointy heads. It's an unusual mixture.
Yeah, because all right, so you have the 5 conservatives plus she is a fairly long-standing one. She was appointed by Obama, correct?
I don't remember, but yeah, she's a supposedly a pointy head, yes.
And so Justice Gorsuch joined the liberal wing of the court on something related to criminal justice.
That's correct. You're correct. But what's even funnier is how he reached his conclusion.
So why is that funny?
Well, because my recollection is Justice Gorsuch is a textualist of the Antonin Scalia camp. And don't we have a clip of Justice Scalia explaining textual interpretation that we could play real quickly?
I do. Here we go. Hopefully it'll work.
A textualist is someone who believes that legal provisions in a constitution or in a statute are to be determined on the basis of the fairest meaning of the text, not by use of such extrinsic factors as what is the general purpose of the statute or what did the Senate committee say when the statute was enacted, but rather just taking the words, which is the only thing that had the assent of both houses of Congress and of the president, or the assent of the people if it's a constitutional provision, and giving those words their fairest meaning.
That was a clip of the late Justice Antonin Scalia explaining textualism, and he explained it very succinctly that justices and judges are not supposed to invent the law. They're supposed to look at the text and give the words the meaning that they had at the time that the words were chosen. And so this decision here is a perfect and classic example of textual interpretation. So that really befuddles me that why Gorsuch would have issues with it, because he's going off the rails and he's going down with the pointy heads on purposivism, as Scalia referred to it.
And as I understand it, the decision involves an ambiguity in the provisions added to federal sentencing law in the First Step Act, with the court coming down on the side of the government. And the problem involves how to read safety valve in federal sentencing laws, which allows defendants to avoid mandatory minimum sentences. The safety valve requires a defendant to satisfy a laundry list of 5 separate rules.
Correct. The case involves the first of those rules, which assesses the defendant's criminal history. Generally speaking, the point of the provision is that defendants with a serious criminal history are not eligible for the safety valve and must serve the normal mandatory minimum sentence. Before the First Step Act, the criminal history provision excluded all defendants with more than one criminal history point. The First Step Act modified that provision. The dispute in the case turned on the meaning of "and" between subparagraphs B and C. The government argued that the phrase creates a checklist of 3 distinct conditions. Pulsifer, the defendant, contended that the phrase does not have A, B, and C, sets out a single amalgamated condition for relief. The court ultimately agreed with the government's more restrictive view. It seems rather simple. Does "and" mean all of the above, or does it mean one of the above?
I'm thinking "and," at least when I do computer coding, Larry, if I say this and this, both have to be true, or both have to be in the affirmative for that to be to go through. So the case resolves a conflict among the lower courts and inevitably will lead to more frequent use of the mandatory minimum sentencing provisions. It will now be up to Congress to act if that was not their intent when they passed the FSA.
Yeah, that was supposed to be me, but somebody who prepared the script messed it up. So
we should fire that person.
okay.
So can I read from the dissenting opinion then?
Yes, I love what Gorsuch said. He's the author of the 3 justice dissent.
All right, well, today the court does not hedge its doubts in favor of liberty. Instead, it endorses the government's implicit distribution theory and elevates it over the law's ordinary and most natural meaning. It is a regrettable choice that requires us to abandon one principle of statutory interpretation after another. We must read words into the law. We must delete others. We must ignore Congress's use of a construction that tends to avoid, not invite, questions about implicit distribution. We must dismiss Congress's variations in usage as sloppy mistakes. So what do you say to that?
Well, I say Justice Gorsuch stated, we must elevate unexpressed congressional purposes over statutory text. Finally, rather than resolve any reasonable doubt about statutory meaning in favor of the individual, we must prefer a more punitive theory the government only recently engineered. That's what I think about that. He has gone off the conservative rails because he's now saying that despite the language here, we have to look at the purpose. And he did a great job. I started reading the dissent, and his articulation of the facts about how the federal prison population has exploded and how that the intent of the First Step Act was to help reduce the explosion of the federal prison population. He's right about all that stuff, but Congress didn't word it clearly and succinctly. And so therefore, he's going down the purpose-driven path.
I've heard you refer to the rule of lenity, and my recollection is that this means any ambiguity in criminal law resolves in favor of the accused?
That is correct, and Justice Gorsuch even referenced that. He stated, as I see it, the government hasn't come close to supplying a lawful basis for departing from the law's ordinary meaning. Suppose, though, at the end of this long march through its inventive theories, you remain unsure. Suppose you are left with a reasonable doubt about whether Mr. Pulsifer or the government has the better reading of the law. In circumstances like that, another rule of construction applies. An answer: it is lenity. He's right about that.
And why did that not carry the day?
Well, because 5 of the 6 conservatives, joined by one liberal pointy head, chose a textual interpretation. But even if that one liberal had not joined the 5 conservatives would have carried the day, because I think, if I can do math, 5 is a majority of 9, right?
I believe so, because 4.5 would be half. So anything over 4.5 would be the majority.
Okay, well, let's do a little bit more math. So I can do one phase of the math. The liberal wing of the court is 3, and so 33 and 1/3% abandoned, and they went off the rails because Kagan is with the textualist crowd. What percentage of the conservative side of the wing of the court went off the rails on this? Can you do that math real quickly?
Isn't it just 1?
Well, there's 1 of 6, so 5 of the 6. What percentage? Isn't that about 83% of the conservative appointed judges went off the rails?
Yes.
Okay, so I would rather take my odds with liberal pointy heads if I'm trying to get a favorable outcome, because 83% of the conservatives were in the wrong side. Only 33% of the liberals were on the wrong side.
I'm with you. And so another comment is, why couldn't they just use a real word like leniency instead of lenity?
Because it's not Latin. But
Larry, we don't have enough time to do this other article.
It doesn't mean the same thing, but lenity means that you could file a motion even in a trial court if a criminal statute is worded in such a way that you can't understand. That accused needs fair notice, and they need to understand what's against the law. So you have that void for vagueness doctrine, and you also have the rule of lenity. If it's a struggle and you can't really figure out, then essentially the tie goes to the runner. So the accused is the one that's going to be in the cage. So if you cannot resolve it, then the doubt is supposed to be resolved in favor of the accused. But that seems to not be very often done these days. But Gorsuch is right about that. But the textualists would come down the way the textualists, 6 of the court's justices, did. The text isn't clear enough in how Congress worded this. Now, the funny thing is, you'll never be able to get anything through Congress to change this as long as we have a Democratic president, because that would be turning a loose tidal wave after wave after wave of criminals on the population. This is something that can only be done by conservatives. They have the political capital to be more lenient on criminal conduct because they are never perceived as being lighthearted. So this is something where you need conservatives to join in to get it done. But with the liberal Congress, you'll never get this done.
Gotcha. Anything else?
I guess that's it. And I'm looking forward. Do we get 2 weeks off starting when, or do we get 1 week off?
It will be 1 week off, and we are going to be here next weekend, and then we will be off the following one because I'm going on a very long drive.
All right. So I got one more
to
show.
To go see something for 4 minutes.
I got one more show to do, and then we have a vacation.
If you say so. So anyway, head over to registrymatters.co for show notes, and then you can go over and leave voicemail at 747-227-4477 like someone did. I didn't send that to you, Larry. I missed it, but I will send a voicemail message to you. Email us over at registrymatterscast@gmail.com. And of course, if you head over to patreon.com/registrymatters, you can support the podcast for as little as $1 a month, and that is most appreciated. You got people hanging out here live in listening in. Those are Patreon people, and I want to thank all of the patrons so very much because they are just the bestest, and they keep this shop open. Because we would have closed up shop a long time ago, Larry. I'm certain of that.
I agree. Thank you very much.
I hope you have a wonderful rest of your evening and weekend, and I will talk to you sometime soon.
Good night.
Have a good night.
You've been listening to FYP.